All right. Donald Trump walked into federal court on Monday morning, knowing this wasn't going to be an ordinary day. For weeks, his legal team had been fighting to avoid what was about to happen. Motions had been filed, arguments had been made, delays had been requested. Every available legal avenue had been explored. None of it worked. The court wanted testimony, and eventually the choice became simple. Take the stand or face the consequences of refusing. So Trump took the stand. At first, everything looked routine. Lawyers moved through stacks of documents. Prosecutors asked methodical questions. Defense attorneys listened carefully, occasionally objecting, occasionally consulting notes. To anyone walking into the courtroom at that moment, it would have looked like a standard day in a complicated financial case. But beneath the surface, something much larger was unfolding. For months, prosecutors had been assembling records tied to property valuations, financial disclosures, loan applications, internal communications, and corporate filings. Investigators had spent countless hours reviewing documents, comparing statements, and tracing decisions across multiple years. Their theory was straightforward. According to prosecutors, certain properties appeared to carry different values depending on where those values were being reported. In some situations, the numbers appeared significantly higher. In others, significantly lower. The defense argued there was nothing unusual about that. Real estate valuations can vary depending on methodology, market conditions, intended purpose, and professional judgment. What prosecutors viewed as evidence of misconduct, the defense viewed as ordinary business practice. That disagreement formed the foundation of the entire case. As testimony began, prosecutors focused on broad issues first. They asked about financial reporting procedures, business operations, and the roles played by accountants, advisors, and executives. Trump repeatedly explained that large organizations depend on teams of professionals. Accountants handle accounting. Attorneys handle legal matters. Executives oversee strategy. Consultants provide recommendations. In a company with countless moving parts, not every decision passes directly through one individual. On its face, the explanation sounded reasonable. Large organizations often function exactly that way. But prosecutors weren't interested in general explanations. They were moving towards something much more specific. Gradually, the questions became narrower. Instead of discussing broad categories of activity, prosecutors began focusing on individual transactions, specific communications, and particular decisions. Dates appeared, property names appeared, specific documents appeared. And with each new question, prosecutors seemed to be moving closer to a destination they had planned long before the hearing began. Observers inside the courtroom began noticing the pattern. Every question appeared connected to a document. Every answer appeared connected to a record. Every statement seemed to lead directly into another piece of evidence waiting to be introduced. Then the documents started appearing. At first, nothing dramatic happened. A document would be presented, a question would follow, an answer would be given, the hearing would move forward. But over time, the pattern became harder to ignore. Prosecutors weren't introducing records randomly. They appeared to be building a chain, link by link, document by document. According to prosecutors, those records showed direct involvement in matters that had just been described differently during testimony. The defense immediately pushed back. Attorneys argued that prosecutors were oversimplifying years of complicated business activity. They argued that memory is imperfect, especially when discussing events that may have occurred years earlier. They argued that isolated emails and individual documents rarely tell the full story. Context matters, timing matters, the broader picture matters. Yet prosecutors continued presenting record after record, each one appearing to support the same narrative. As the afternoon progressed, the atmosphere inside the courtroom began to change. What started as a technical discussion about financial records slowly transformed into something much more serious. The focus was no longer simply on property valuations or reporting practices. The focus was becoming credibility. Every answer carried greater weight because every answer could potentially be measured against evidence sitting in the government's files. Objections became more frequent. Attorneys approached the bench. Side discussions interrupted the flow of testimony. The judge listened, ruled, and allowed questioning to continue. But the tension was becoming impossible to ignore. By this point, prosecutors appeared increasingly confident. They weren't asking speculative questions. They weren't fishing for information. They seemed to know exactly where they were going. The defense remained aggressive, insisting that prosecutors were confusing association with responsibility. Being copied on a communication doesn't necessarily mean directing a decision. Seeing a document doesn't necessarily mean approving it. Participating in a conversation doesn't necessarily mean controlling the outcome. Those distinctions form the core of the defense's argument. But prosecutors appeared convinced they had evidence capable of overcoming those explanations. Then came the shift that everyone would later talk about. Up until that point, the hearing had centered on documents, records, emails, and financial paperwork. But prosecutors had something else waiting, something different, something that neither side viewed as routine. It wasn't another valuation report. It wasn't another loan application. It wasn't another email chain. It was a recording. And according to both sides, what happened after that recording entered the discussion changed the entire trajectory of the hearing. Prosecutors believed it strengthened their case dramatically. The defense believed it raised serious procedural and legal concerns. The judge would soon be forced to decide how much weight it deserved. And once that decision arrived, the legal battle would enter an entirely new phase. What began as a dispute over financial records was about to become a fight over evidence itself. The hearing had already become more tense than anyone expected, but what happened next pushed it into entirely different territory. Up until this point, the battle had centered on documents, emails, financial records, property valuations, internal communications, the usual paper trail that follows almost every major financial investigation. But prosecutors weren't finished. According to people following the case closely, they had been building toward a much more significant piece of evidence. And when they finally introduced it, the reaction inside the courtroom was immediate. The moment the recording was mentioned, defense attorneys were on their feet. Objections came quickly. Lawyers approached the bench. The judge called for a sidebar conference. What had been a relatively structured examination suddenly turned into a heated legal argument. Prosecutors maintained that the recording was highly relevant and directly connected to testimony that had just been given under oath. The defense disagreed completely. Their argument wasn't necessarily about what the recording contained. Their argument focused on how it was being introduced, when it had been disclosed, and whether it should even be considered admissible at this stage of the proceedings. For nearly half an hour, attorneys argued their positions while everyone else waited. Court observers could see the intensity of the discussion, even if they couldn't hear every word. Prosecutors appeared determined to get the evidence into the record. Defense attorneys appeared equally determined to keep it out. The judge listened carefully, reviewed the arguments, and eventually made a decision. The hearing resumed. From that point forward, the atmosphere inside the courtroom felt completely different. Prosecutors argued that the recording directly contradicted portions of testimony that had been given earlier in the day. According to their interpretation, it provided a level of detail that documents alone could not. The defense immediately pushed back, insisting that conversations can be interpreted in different ways, and that isolated excerpts rarely tell the full story. Context, they argued, was everything. Remove enough context from any conversation, and almost anyone can appear to have said something they didn't actually mean. But prosecutors weren't relying on the recording alone. They continued introducing additional evidence. More communications, more financial records, more internal discussions. Piece by piece, they attempted to build a larger picture. According to prosecutors, the various documents supported one another. Individual records that might seem insignificant on their own appeared more important when viewed together. The defense rejected that interpretation. They argued the government was connecting unrelated events and presenting assumptions as conclusions. What prosecutors called a pattern, the defense called a narrative. As the evidence accumulated, the courtroom began focusing less on the underlying financial issues and more on the testimony itself. The central question was changing. At the beginning of the hearing, the debate had been about valuations and business practices. Now, the debate was becoming much narrower and much more dangerous. Were the statements being made under oath consistent with the available evidence? That's the point where legal analysts started paying very close attention, because financial disputes can drag on for years. Arguments about valuation methods can continue indefinitely. Experts can disagree. Appraisers can disagree. Accountants can disagree. But disputes involving sworn testimony operate under a different set of rules. Once testimony becomes the focus, every answer matters. Every word matters. Every statement becomes subject to examination against whatever evidence exists. The defense recognized that immediately. That's why their strategy shifted toward procedure as much as substance. They argued that certain evidence should have been disclosed earlier. They questioned the timing of its introduction. They raised concerns about fairness and due process. Even some outside legal observers noted that procedural questions could become important later, particularly if the case eventually reached an appellate court. Meanwhile, prosecutors appeared increasingly confident. Their questioning became more direct. Their arguments became more focused. They seemed convinced that the documentary record supported their position. Every new exhibit appeared designed to reinforce a specific point. Every new question seemed aimed at narrowing the available explanations. By the end of the day, neither side appeared willing to give an inch. The prosecution believed the evidence spoke for itself. The defense believed the government's interpretation was deeply flawed. The judge now sat in the middle of a rapidly escalating dispute with major consequences for both sides. And then everyone left the courtroom. But the story wasn't over. Not even close. Because while attorneys were preparing new motions and legal analysts were debating the day's events on television, the judge was reviewing everything that had happened. Every argument, every objection, every piece of evidence, every statement made under oath. And before the next day was over, a ruling would arrive that would change the direction of the entire case. What happened after that ruling is where the real fallout begins. When court adjourned that evening, both sides walked away believing they had gained ground. Prosecutors felt they had successfully challenged key portions of the testimony. The defense believed they had created enough procedural questions to undermine the government's case. Outside the courthouse, legal commentators immediately began debating what had happened. Some focused on the evidence itself. Others focused on how that evidence had been introduced. But everyone was waiting for the same thing, the judge's response. Hours passed, then more hours. No ruling, no statement, no indication of which way the court was leaning. Attorneys on both sides continued preparing for every possible outcome, while legal analysts dissected every moment of the hearing. Some believed the judge would simply allow the case to proceed as normal. Others thought the day's events had raised issues too serious to ignore. The uncertainty only added to the tension. Late that night, attention suddenly shifted. A new filing appeared on the court docket. Within minutes, lawyers, reporters, and courtroom observers were reading through every line, trying to understand exactly what the judge had decided. And that's when the fallout began. The ruling didn't end the dispute. It intensified it. Prosecutors immediately pointed to the decision as evidence that the court shared at least some of their concerns regarding the testimony and the evidence presented during the hearing. The defense saw something very different. From their perspective, the ruling raised even more questions about procedure, fairness, and the handling of evidence throughout the case. Almost immediately, new legal battles started forming. Emergency motions were discussed. Appeals were considered. Additional filings were prepared. What had started as a dispute over financial records was evolving into a much broader confrontation involving credibility, procedure, and judicial authority. The reaction extended far beyond the courtroom. Supporters of the prosecution argued that accountability under oath must apply equally to everyone. They viewed the developments as evidence that the legal system was functioning exactly as intended. If contradictions existed between testimony and documentary evidence, they argued those contradictions deserved scrutiny regardless of who was involved. Supporters of the defense reached the opposite conclusion. They argued that procedural safeguards exist for a reason. In their view, questions about evidence disclosure, timing, and fairness could not simply be ignored because the case involved a high-profile defendant. To them, the larger issue wasn't just what evidence existed. It was whether that evidence had been handled properly throughout the process. As the debate intensified, legal experts across the country began weighing in. Former prosecutors discussed how similar situations had been handled in previous cases. Defense attorneys analyzed potential appellate arguments. Constitutional law scholars examined due process concerns. Financial fraud specialists focused on the underlying allegations. The case was no longer just attracting political attention. It was becoming a subject of serious legal discussion. Several themes quickly emerged. First, there was the question of evidence disclosure. Defense attorneys continued arguing that certain materials should have been presented earlier, giving them more time to prepare responses. Prosecutors insisted they had complied with their obligations and that the evidence was both relevant and properly introduced. Second, there was the issue of credibility. At this stage, much of the dispute centered on competing interpretations of the same events. Prosecutors believed the records supported their version of what happened. The defense believed those same records could be understood very differently when viewed in context. Third, there was the broader question of precedent. Legal observers understood that whatever happened next could influence future cases involving testimony, documentary evidence, and procedural disputes. Lawyers across the country were watching closely, not necessarily because of the individuals involved, but because of the legal principles at stake. Meanwhile, neither side showed any signs of backing down. Prosecutors continued preparing for the next phase of the case. Defense continued preparing new challenges. Additional hearings were scheduled. More arguments were expected. And according to people following the case closely, there was still one major question hanging over everything. What other evidence, if any, remained undisclosed? Because throughout the hearing, prosecutors had projected confidence. The defense had projected resistance, but neither side had revealed every card in its hand. That's often how major cases unfold. What appears decisive one week can become far less important the next once new information emerges. And that's exactly why the next hearing suddenly became one of the most anticipated events in the entire case. Everyone wanted answers. What would prosecutors present next? How would the defense respond? Would the judge signal where the case was heading? Or would the legal battle become even more complicated? At this point, one thing was becoming increasingly clear. This was no longer simply a case about financial records. It was a fight about testimony, a fight about evidence, a fight about procedure, and most importantly, a fight about which version of events would ultimately survive legal scrutiny. The next hearing wouldn't necessarily resolve those questions, but it would almost certainly bring the case to another turning point. And if the developments so far were any indication, that turning point could arrive sooner than anyone expected. As attention shifted toward the next hearing, something else started happening behind the scenes. The courtroom battle was no longer confined to prosecutors, defense attorneys, and the judge. Now, the wider legal world was getting involved. Former federal prosecutors were publishing analyses. Defense attorneys were appearing on television. Legal scholars were writing lengthy breakdowns of the procedural questions raised during the hearing. Everyone seemed to agree on one thing. Whatever happened next could have consequences far beyond this single case. The prosecution's position remained straightforward. They argued that documentary evidence should carry significant weight when evaluating sworn testimony. From their perspective, the issue wasn't political. It wasn't personal. It was evidentiary. Documents existed. Communications existed. Records existed. The question was whether those records aligned with the statements that had been made under oath. Prosecutors believed they did not, and they appeared increasingly confident in their ability to prove that argument as the case moved forward. The defense saw the situation very differently. Their focus was no longer limited to the evidence itself. Increasingly, they were concentrating on how that evidence had been obtained, disclosed, and introduced. They argued that procedure matters just as much as substance. In any legal proceeding, they said, defendants are entitled to understand the evidence being used against them and to have a meaningful opportunity to respond. If that process breaks down, even strong evidence can become controversial. As both sides dug in, observers began noticing a larger pattern. The case had evolved through several distinct stages. At first, it was about financial records. Then it became about testimony. After that, it became a battle over evidence. Now it was becoming a battle over the process itself. And those battles can be difficult to predict because unlike factual disputes, procedural disputes often continue long after the underlying evidence has been presented. Appeals can focus on procedure. Higher courts often focus on procedure. Entire cases can be reshaped by procedural rulings. That's why lawyers on both sides appeared to be preparing not just for the next hearing, but for everything that might come afterward. Meanwhile, speculation continued growing. Would prosecutors introduce additional evidence? Would the defense seek broader discovery? Would new witnesses be called? Would appellate courts become involved? Every possibility remained on the table. The uncertainty created a strange situation. On one hand, both sides were speaking with confidence. Prosecutors projected certainty in their evidence. The defense projected certainty in its challenges. Yet beneath that confidence was a reality every experienced lawyer understands. Major cases rarely move in a straight line. Unexpected rulings happen. New evidence emerges. Witnesses change strategies. Legal theories evolve. What appears decisive one week can become far more complicated the next. That's exactly why the upcoming hearing attracted so much attention. For prosecutors, it represented an opportunity to strengthen the narrative they had been building from the beginning. Every document introduced, every communication presented, every argument advanced seemed aimed at reinforcing a central claim. They wanted the court to view the evidence as a consistent pattern rather than a collection of isolated incidents. The defense had a different objective. Their goal was to break that pattern apart, to show that prosecutors were connecting dots that didn't actually belong together, to demonstrate that context had been removed, assumptions had been made, and conclusions had been reached too quickly. They weren't necessarily trying to win every argument immediately. Sometimes the goal in a complex legal battle is simply to create enough doubt to keep larger questions alive. The judge remained at the center of it all. Every major dispute eventually returned to the bench. Every disagreement required a ruling. Every procedural challenge required a decision. While commentators debated the case publicly, the court continued focusing on the evidence, the law, and the arguments presented by both sides. Then reports began circulating that additional motions could be filed before the next hearing. That got people's attention because new motions often mean new issues. New issues can mean new evidence, and new evidence can completely change the trajectory of a case. Suddenly, lawyers, reporters, and observers were looking beyond what had already happened and focusing on what might happen next. What documents hadn't been discussed yet? What communications hadn't been introduced yet? What arguments were still waiting to be made? Those questions became the center of attention. The deeper people looked, the more they realized something important. Despite all the headlines, despite all the commentary, despite all the debate, the story was still incomplete. The hearing that had generated so much attention might eventually be remembered as only the beginning. Because the next phase wasn't just about reviewing what had already occurred. It was about determining where the case would go from here. And if the previous hearing taught everyone anything, it was this. The developments that attract the most attention are often the ones nobody sees coming until they're already happening. That's why the days leading up to the next court appearance became a waiting game. Prosecutors were preparing. The defense was preparing, the court was preparing, and everyone else was watching, waiting for the next filing, waiting for the next ruling, waiting for the next piece of evidence. Because in a case that had already produced so many twists, few people were willing to assume the biggest developments were already behind them. By this point, the case had taken on a life of its own. What began as a courtroom dispute was now being analyzed from every possible angle. Legal experts were debating the evidence. Political commentators were debating the motivations. Financial analysts were debating the implications. But inside the courtroom, none of that mattered. The only thing that mattered was what could be proven, what could be challenged, and what the court ultimately decided to accept. As the next hearing approached, both sides intensified their preparations. Prosecutors continued reviewing documents, organizing evidence, and refining the timeline they intended to present. Their strategy appeared increasingly focused on demonstrating consistency. Every communication, every record, every financial disclosure was being positioned as part of a larger narrative. They wanted the court to see a pattern, not isolated events, not individual misunderstandings, a pattern. The defense was preparing just as aggressively. Their approach focused on dismantling that pattern piece by piece. According to defense attorneys, prosecutors were connecting events that didn't necessarily belong together. They argued that business decisions often involve multiple people, multiple interpretations, and multiple layers of review. What might appear obvious when looking backward can be far less clear when viewed in real time. The defense believed the government was presenting certainty where uncertainty actually existed. And that's where the battle became especially complicated, because both sides were working with many of the same documents. The disagreement wasn't always about whether records existed. The disagreement was about what those records meant. A single email could support two completely different arguments. A single conversation could produce two completely different interpretations. A single financial document could generate endless debate depending on who was analyzing it. That reality became increasingly important as anticipation for the next hearing continued to grow. Court observers began focusing on several unanswered questions. Would prosecutors introduce additional communications that hadn't yet been discussed publicly? Would new witnesses be called to support either side's interpretation? Would the defense present evidence that challenged the government's timeline? Every possibility seemed open. Meanwhile, attention started shifting toward the broader implications of the case. Because regardless of the final outcome, the legal questions being raised extended beyond the individuals involved. Attorneys handling financial cases across the country were watching closely. Corporate compliance departments were watching closely. Legal scholars were watching closely. The issues at stake touched on testimony, documentation, disclosure obligations, and evidentiary standards, subjects that influence countless cases every year. That's why every new filing attracted attention. Every motion generated analysis. Every ruling generated debate. The case had become more than a dispute between two sides. It had become a test of competing legal theories. Prosecutors argued that the documentary record spoke for itself. The defense argued that documents without context can create misleading conclusions. The court would eventually have to decide which interpretation carried more weight. As the hearing date approached, reports indicated that both sides were expected to present additional arguments regarding evidence and procedure. That immediately sparked new speculation. Additional arguments often mean unresolved disputes. Unresolved disputes often mean further rulings, and further rulings can dramatically alter the direction of a case. The uncertainty only increased public interest. People wanted answers. What evidence had not yet been revealed? What arguments remained behind closed doors? What strategic decisions were being made that nobody outside the legal teams could see? Those questions lingered over every discussion. And perhaps most importantly, nobody knew whether the most significant moment of the case had already happened or whether it was still ahead. History is full of legal battles where early developments attracted enormous attention, only to be overshadowed later by something even bigger. Experienced attorneys understand that. Judges understand that. Prosecutors and defense lawyers understand that. That's why neither side appeared interested in declaring victory. The prosecution continued preparing. The defense continued preparing. The court continued reviewing. And everyone else continued watching. Because despite everything that had already happened, despite all the testimony, all the documents, all the arguments, and all the controversy, one reality remained unchanged. The case was still moving forward. More hearings were coming. More evidence could emerge. More legal challenges could be filed. And with each new development, the stakes appeared to grow larger. The next chapter wouldn't simply determine what happened next in this case. It could help determine how the entire story would ultimately be remembered. And if the events so far had proven anything, it was that certainty remained in short supply. The only thing anyone could say with confidence was this: the fight was far from over. As the next phase of the case approached, the focus began shifting away from what had already happened and toward what might happen next. That's often the point where major legal battles become even more unpredictable. Early hearings establish the battlefield. The later stages determine who can actually hold their ground. And by now, both sides had invested too much time, too many resources, and too much public credibility to back away. Prosecutors appeared determined to keep building momentum. From their perspective, every hearing had added another layer to the record. Every document introduced had strengthened their narrative. Every disputed communication had provided another opportunity to argue that the evidence pointed in a consistent direction. Whether the court ultimately agreed remained to be seen, but prosecutors clearly believed they had established a foundation strong enough to carry the case forward. The defense viewed the situation differently. Their argument had evolved over time, but the central theme remained the same. Context matters. They continued insisting that prosecutors were reducing complex business activity into simplified conclusions. Large organizations generate enormous amounts of communication. Thousands of emails, countless meetings, endless discussions involving multiple people making decisions for different reasons. Pulling isolated records from that environment, they argued, creates a risk of misunderstanding how decisions were actually made. That disagreement now sat at the center of everything, because the case was no longer just about documents. It was about interpretation, not just about evidence, about meaning, not just about what happened, but about how what happened should be understood. And those are often the hardest legal disputes to resolve. As attorneys prepared for future proceedings, attention increasingly turned toward the long-term implications. Regardless of the outcome, legal professionals across the country were watching carefully. Cases involving financial disclosures, testimony, documentary evidence, and procedural challenges appear in courtrooms every year. The principles being debated here could influence arguments in future cases far removed from this one. That reality added another layer of significance. Every ruling mattered, every filing mattered, every argument mattered. Not necessarily because it would determine the final outcome immediately, but because each development contributed to a larger legal framework that other attorneys, judges, and courts might eventually examine. Meanwhile, public interest remained intense. Supporters of the prosecution continued, arguing that the evidence deserved to be taken seriously and that no witness should be exempt from scrutiny simply because of status or position. Supporters of the defense continued arguing that procedural fairness and due process protections must remain central, regardless of public pressure or political attention. Neither side appeared willing to change its position. If anything, the divide seemed to be growing. The legal battle was becoming a reflection of two competing ways of viewing the same events. One side looked at the record and saw accountability. The other looked at the same record and saw overreach. One side believed the evidence spoke clearly. The other believed the evidence was being interpreted selectively. And somewhere in the middle sat the court, reviewing filings, examining evidence, evaluating arguments, moving through the process one step at a time. That's often the least dramatic part of a major case, but it's usually the most important. Headlines move quickly. Public opinion shifts constantly. Court proceedings move much slower. Judges focus on records, evidence, testimony, and law. Everything else tends to fade into the background. As the timeline moved forward, more hearings remained on the schedule. Additional motions were expected. Legal challenges were likely. New arguments would almost certainly emerge. That's the nature of high-profile litigation. Cases evolve. Strategies change. Unexpected developments appear. What seems significant one month can be replaced by something even more significant the next, which brings us to the biggest question of all. Where does this go from here? At this stage, nobody knows. Not the commentators, not the analysts, not the lawyers appearing on television every night. The only certainty is that the process is still unfolding. More facts may emerge. More evidence may be introduced. More rulings will be issued. And each new development will shape the direction of the case. For now, that's where things stand. A legal battle that began with questions about financial records has expanded into a much larger debate involving testimony, evidence, procedure, accountability, and the interpretation of complex events. Both sides remain convinced they are right. Both sides continue preparing for the next round. And the court continues moving forward one decision at a time. The story isn't over. The arguments aren't finished. The evidence isn't fully explored. And the final outcome remains uncertain. What happens next could reinforce everything we've seen so far. Or it could change the entire picture again. That's why lawyers are watching. That's why commentators are watching. That's why the public is watching. Because in cases like this, the most important chapter is often the one that hasn't been written yet.